the burden is now put back on the states to fight a case, to convince the court that the governor's delay is glaring.
By default, a politically driven governor, a politically minded governor, could just sit on it indefinitely until the state government goes to court.
What you're saying, Sampath, is true. Nobody can deny that. The court should have a basic threshold of 3 months. It should be only a threshold for judicial review, not an amendment of the Constitution.
Hello and welcome to In Focus. I'm G. Sampath. A 5-judge bench of the Supreme Court has given its opinion on the 16th presidential reference. This reference pertained to the powers of the governor and the president when it came to bills passed by state legislatures. The Supreme Court has said that no timelines can be fixed for governors or the president to act on bills passed by state legislatures. This advisory opinion of the Supreme Court contradicts its own judgment of April the 8th in the State of Tamil Nadu versus Governor of Tamil Nadu and Union of India. In this case, the 2-judge bench of Justices J.B. Pardiwala and R. Mahadevan had held that the governor cannot exercise a pocket veto by indefinitely sitting on bills, and they fixed a 3-month timeline for them to act on the bills that come to them. So what happens to this judgment now? Former Chief Justice B.R. Gavai did clarify that the opinion given in a presidential reference does not overrule a judgment. Does the court's opinion mean that the centre now enjoys a default pocket veto on state laws? Does it mean that governors can sit on any bill as long as they like, waiting for states to go to court? We speak with Krishnadas Rajagopal, the Hindu's legal correspondent. Krishna, welcome to In Focus. Thank you so much for joining us today.
Always a pleasure.
So, to start with, can you explain for our audience what exactly is a presidential reference? When is it invoked? And this particular one, the 16th presidential reference, what are the questions that have been raised in this reference?
So I'll start with the first question. That is, a presidential reference is the Supreme Court. Is the president actually asking the Supreme Court to help her wrap her head around an issue of constitutional importance? Here, I'm loosely saying that it's like a person going to a very senior lawyer for an opinion, for an advice. So under Article 143 of the Constitution, the President invokes the advisory jurisdiction of the Supreme Court in a matter which has public importance, national importance, and gives a set of questions saying that, please help me with this. I need a better understanding of these, and mostly of these constitutional issues, and they pertain to the court's role as an interpreter of the Constitution. The court sits as a 5-judge bench or a larger bench. We've had 7 judges also, and it basically goes through all her questions and answers the questions and sends it back to her as an advice. It's an opinion, unlike a judgment, which is binding. A judgment comes under the adjudicatory jurisdiction of the court.
Before we come to this particular reference, I wanted to ask you, is there some kind of a context or an event which triggers a presidential reference, or the government can just without any particular reference to anything which is happening, just seek a Supreme Court advice on some issues?
It can be. It can have a presidential reference can be triggered either by a factual circumstance or a legal circumstance, even an order of the court. You know, the first presidential reference in 1951, it was triggered by a federal court order, where the federal court, under the Delhi Laws Act 1912, so the federal court basically said that some legislative functions can be passed on, delegated to the executive, certain lawmaking functions. So we had the famous 1951 presidential reference, which is the first one, in which the Supreme Court said that, listen, yeah, it can be done, but not the core legislative functions, but the ancillary legislative functions, rule making, administrative law, delegated legislations can be done by the executive. So we have, and then we have the 2012 2G case, where it was a court ruling, the Supreme Court's own ruling, on how a natural resource can be, should it be auctioned, or should be, how do we distribute a natural resource? In this case, the spectrum, where the court said in the 2012 this thing in the judgment that it can only be done through auction. Because the policy was first come, first serve basis. So they struck it down and they said only through auction. There also the Supreme Court said that, listen, auction need not be the only way. It is the preferable way, but it need not be the only way. So these can be any doubt that creeps into the president's mind. I'm saying president is the front, but the central government on how to govern, how to carry on this, how to implement it on the ground. Because there may be some gap between what the Supreme Court says and how it can be implemented on the ground. So these issues can be weaved into a constitutional issue and presented before the Supreme Court for clarification. So it's basically an advice, like advise me on what do you mean by this, and how this can be done, what is the law on this. It's like asking a very senior lawyer to study the problem.
So why not ask your Attorney General, Solicitor General?
The Attorney General is invited by the Supreme Court in the reference. The Attorney General is mandatorily invited, and he is asked to give his opinion. But the opinion, because there is a constitutional obligation on the part of the Supreme Court as an advice giver, as an interpreter of the Constitution, the final arbiter of the Constitution, the President being the highest constitutional authority, what fits her office is to ask the Supreme Court itself. It's actually what we may later on talk about the dialogic process.
Right, we'll come to dialogic in a bit. Yeah. So, in the 2G case, the presidential reference was connected to a ruling, and it sought a clarification on that ruling.
The Center for Public Interest Litigation, the NGO, if I'm right.
So this 16th presidential reference, would it be correct to say it sought to clarify the judgment of April the 8th given by the two-judge bench, Justices Pardiwala and Mahadevan, on the State of Tamil Nadu versus the governor? They wanted that judgment to be clarified, and that's why all these questions, like they pertain to the powers of the governor and the president with regard to their responses and actions on a state bill that has been passed and which is awaiting their assent. So is this reference related to this judgment?
It is, but it's not said so.
It doesn't say so
by the president. It is in all, and even the Supreme Court agrees, confirms it. So we can safely say yes. Because the judgment, the 111-page judgment, is full of the Tamil Nadu governor judgment. And also the dates, because on April 8th, you had the Tamil Nadu judgment. On May 13th, the reference comes to the Supreme Court.
So in the case of the 2G case, the reference was explicit, right, in the presidential reference?
Yeah, they said that.
In this case, why was there is no reference directly?
So government basically says that there are a lot of decisions in the past which gives conflicting opinions. You have the Punjab and Telangana judgments, which was probably in the previous year and the late 2024 and early 2025, which says that the governor has to act as soon as possible. It doesn't specify the timelines. And here you have a judgment which says a particular timeline, let's say a 1 month to 3 month timeline. So they say that these are mixed messages, which is so how do we govern? How do we? So the governance would be in chaos if we go by what you. So we want a clarity on the implementation. So it makes it a question of law rather than as a very smartly rather than as an appeal. Though the petitioners say that this is an appeal in disguise, the center uses the fact that it has not referred to the Tamil Nadu governor's case in its to its advantage by saying that no, we are not challenging or we are not appealing that judgment. We just want a clarification of the law because there's so many judgments on this issue. Why don't you give us an advice on what is actually the law?
Okay. Okay. Now let's come to the actual advisory opinion. Basically, it says in like complete contradiction of the April 8th judgment, it says that you cannot have any timelines. Okay, no, that is number one. Number two, the governor has discretionary power. Okay, and number three, because there are no timelines, there is no such thing as deemed assent at the end of whatever timeline. So all these 3 points, and I'll just read out this one particular sentence from the 2-judge bench verdict. It says, I quote, any discretion available to the governor under the Government of India Act 1935 became unavailable on the implementation of the Constitution. So, even if you look at, let's say, the high school civics textbook understanding of how these things work, legislating a bill is the job of the assembly, whether at the center or at the state level. The assembly, the MPs, they discuss, they vote, and a bill is passed, and then it goes to the governor for his assent. Most of the time, he's expected to assent. It's not a collaborative process between the assembly and the governor. The process involves the assembly, and then once it is completed, it goes to the governor in the next stage. But here, by giving this entire logic of dialogic enterprise and a joint operation between the governor and the assembly with regard to legislation, is this sort of giving a completely new spin on the role of the governor, giving him more power than we have over the last 70 years of constitutional understanding grown to expect?
No, as you say, the dialogic process is the court is interpreting it as a check and balance system, where if, let's say, on the other hand, let's take the other side, the state passes a law, not now, maybe later, maybe 20 years, 25 years later, passes a law which is saying that we want to be split from the country. We don't accept, we don't accept ourselves as part of India or something, and we don't agree to certain core policies, the welfare issues. If you're saying that the governor doesn't have the discretion to question or return the bill or refer it to the president, which is like referring it to the center and saying
that there is no dispute on that. The dispute is on the time he can take.
Exactly. So let me just finish this. So in that case, then if the governor is there to agree to everything that the state as an assembly, even if there is a will of the people, because the elected representatives are the representatives of the people, and the voice of the people is the legislation, then the governor has a legislative duty under Article 200 to question and say that I don't agree with this. Why don't you change these things? Or he can disagree in toto and send it to the president. And it's also the fact that that the very interesting thing is that when you talked about the Government of India Act, the discretion of the governor, Section 75 is I think what you were referring to. Government of India Act had given the governor discretion. And then during the Constituent Assembly debates, and the draft article for Article 200, which is assenting the governor's power to assent to bill, which is now Article 200, it was in the draft article was Article 175. That said that let's not give any discretion. So Ambedkar, when he was discussing it, said that let's not give the governor any discretion. But a few days before, when he said this, the same Constituent Assembly debates, Dr. Ambedkar had said that I think we need to give discretion to the governor. So there was a lot of debate about what the discretion is. But the Supreme Court here, it has basically said that governor has discretion, but a very limited discretion. Assent, withhold, and you have to return with comments to the state assembly, or you can refer it to the president. So the thing is that what we here see is that there can't be any glaring circumstances of the governor sitting for 6 years and 7 years. In that case, the state can approach the Supreme Court and say that there's something like this. Why don't you invoke your judicial review and look at that? Why he is delaying this thing? So that check and balance at every stage they're trying to bring out. But on the other hand, the burden is now put back on the states to fight a case, to convince the court that the governor's delay is glaring and not needed.
You've explained basically the text of the law, which is also what I think the 5-judge bench has largely sort of tried to do. But there is also the context of this particular issue, which is that we have seen time and again, not just in recent years, but also going back more than a decade, 2 decades, 3 decades, that there have been instances of governors sitting on bills for a long period of time without any of the instances, the dangers you pointed out, somebody wanting to, secede or, something which goes directly against the constitution. In this particular case, the 10 bills of Tamil Nadu were to do with vice chancellorship appointments. It's clearly not something of grave constitutional danger. Okay, so this kind of an advisory opinion, do you think it could sort of create a situation where by default a politically driven governor, a politically minded governor, could just, any bill which comes to him or her could just sit on it indefinitely until the state government goes to court? He doesn't need to do anything. He can just sit when the state government goes to court and then the Supreme Court says, please, this is glaring, this is too much, then okay, some action will happen. Wouldn't that then create a lot of problems, litigation, etc., which could have been avoided, let us say, when there is some kind of a reasonable timeline being given?
See, the point is that, there is a fine balance there. On one, what you're saying, Sampath, is true. Nobody can deny that, because we have seen that happen. In the case of the Tamil Nadu governor, these bills date back to 2020, and they were repassed in a special sitting by the Tamil Nadu Legislative Assembly, and he sat there for 5 years, and then once this was repassed and sent back to him, he, without a word, he sent it to the president for consideration. And I believe the president selected only 7 of the 10. So this is a reality. But on the other hand, you have, interestingly, the governor's oath and the president's oath is to protect and defend the constitution. So you have the governor cast as a neutral constitutional head who will protect the principles of the constitution. Now, the court has to believe that. The court has to say that, yes, the governor is neutral. And it cannot prejudice the office of the governor by saying that governors are political, so we're going to fix 3-month timelines. And as far as this judgment is concerned, the defense by or the advisory opinion says that since the constitution is silent, there's nothing said in the constitution about timelines, we cannot encroach into the domain of the governor, and we cannot impose timelines on him, and if he doesn't pass the bill or decide on the bill, then we cannot use our powers to assent to bills. Because
there was one particular article 142 or something.
142, the invoking for complete justice. So we cannot have judges sitting and saying that, okay, the governor has not passed 3 months or 4 months, and let's just pass. This bill is passed. Because there is a consideration, there is an application of mind by the governor or the president, and there is a process which is written in the constitution, which is specifically written in the constitution. Of course, there are no timelines, because timelines are not there because all bills are not uniform. There may be bills with complex issues, there may be bills with very routine bills, which can be passed in a month. It can be complex bills which need to have heavier consideration, which has to be sent back to the union cabinet or the state assembly, because the president, once the bill is referred to the president by the governor, the President returns, there's a way back also in 201. The president says, I have certain questions about this bill. So it returns the bill to the governor saying that you ask the state assembly to answer my questions, and the state assembly has to answer these questions in 6 months. So that's what you call this whole thing of, in a democracy, the dialogic thing, all these checks and balance playing out. Now, when a Supreme Court judgment, with all good intention, I'll talk to you about that later, because I don't think that's what Pardiwala intended, to assume the role of a governor or a president. So, but what they saw was that you have this suddenly a Supreme Court judgment, a judicial order saying that you decide in 3 months or the bill is passed. So in a way, you're cutting short this process of check and balance. You're saying that whatever the bill be, 3 months you decide or it's deemed assent. It seems a little drastic, which is what the judgment says. This deemed assent thing, if you read the April 8 judgment carefully, he is not saying that I want to inject this 3-month deadline into the constitution, because the government had argued that this imposing 3-month deadlines for the governor and the president would mean amending the constitution. So he never thought, the judgment, the April 8 judgment, Justice Pardiwala, the bench had said that we don't want these timelines to be incorporated into the constitution. We want a basic threshold for the Supreme Court. So when a party comes, a state comes to the Supreme Court saying that, the governor is sitting on our bills, so there should be the court should have a basic threshold of 3 months. It should be only a threshold for judicial review, not an amendment of the constitution. I hope you get the point.
Yeah, I get the point. I mean, if the problem here is that 3 months is arbitrary and too little, then you come up with some other timeline. The answer is not no timeline, because we have had examples of bills being held up for 6 years, 7 years. Where is 3 months and where is 7 years? Okay, fix a timeline of 1 year.
But who will fix it is the issue. Isn't it?
Whatever Supreme Court declares is the law. You have been asked to declare the law.
Yes, it's still the law. Now, that's the other point. It's still the law. The government, if you read again the presidential reference opinion, doesn't say that we have come here for you to sit and appeal, or we want you to amend this judgment or anything. It's a very clever ploy. They're basically saying that we want an opinion from you so that it will help us in our future governance.
So what is the legal weight of this opinion? When all said and done, what are we going to do with this opinion? Because there is already a judgment which is saying something else.
Yes, the judgment is still there. It's it's two different jurisdictions. One is an advice, the other is a judgment. And as far as the judgment is concerned, all judicial and civil authorities have to comply with the judgment. The opinion, on the other hand, is it can be used by the government to maybe use it as a change in legislation if they want, but then they would have to again amend the constitution and go to different states, and there's a whole cumbersome process of change and all that. But these are two different. All we can say is that the judgment is binding, whereas there is an opinion which could be probably used as a measure to clarify things or to make things clear. But I think it's completely muddied the water here in a way.
So one other concern which many legal experts have raised with this advisory opinion is that it sort of undermines the federal principle by sort of leaning more in the direction of the executive, because the governor is an agent of the central government, so the central executive, by giving him or her some sort of a pocket veto. Pocket veto is a term which the April 8th judgment did use, saying you cannot have a pocket veto. Now, is that would you agree with that, as that concern that the federal principles have been sort of slightly diluted in this judgment? Because if the governor is a constitutional authority and we must trust in his or her wisdom and judgment and so on, So is the state assembly. They are also constitutionally sort of robust entities. Why should we look at whatever bills they pass with a default stance of suspicion? So there is that counter as well.
Yeah, I think at the end of the day, the burden is back on the states to make a case of a governor's delay. The states have to go to the court. The states have to fight the case, and then it's left to judicial discretion or to look into why the governor has delayed, whether the delay is reasonable or not. And even if the court holds that your delay is unreasonable, please do it within a reasonable time. Is the governor bound by such a request? We have seen that in the Tamil Nadu governor's case, where despite there were many before the April 8 judgment, they were the division bench, Justice Pardiwala and Justice R. Mahadevan, they were very reluctant to take up this case. They kept asking the governor and the Tamil Nadu state of Tamil Nadu to sit together, have a cup of coffee, and sort out your issues.
That was precisely an example of dialogic approach, right? Not adversarial. It was dialogic
process. But it didn't work. They wanted a litigation, and they got the judgment. They got the particular judgment. So, interestingly, Sampath, what I have to say is that there's a February 2016 office memorandum from the government, from the Home Ministry, which says that, listen, these governors are delaying all these bills, and it's really hampering state governance. So we have to, and it's really hampering federalism. The states are running helter-skelter to get their bills passed. Welfare, most of them are crucial bills, education, health, and all that. So let us impose 3-month deadlines on the governors. And Pardiwala uses these office memorandums as a reason for saying that that's why I want 3 months, because you yourself, the center yourself, had finalized the 3 months. You had zeroed in on 3 months as a reasonable period. So we'll just say that 3 months. That's how this exact timeline has come in. But then the opinion says that these are office memorandums. And we are not bound by these office memorandums. The opinion, November 20 opinion, completely dismisses these office memoranda of the Home Ministry. So there is this underlying issue of governors are delaying, as you said, not just now, but for decades. They have been doing it for one reason or the other, maybe for a very good reason or for a political reason, what may be. But there have been delays by the governor, even the president. But the court has not been able to address it, except for the fact that they have been saying that you should do it in a reasonable period, and it's not there. The Constitution is silent about it. So it's a catch-22 situation.
Right. This is maybe the last question I have for you. We're running out of time. So one of the reasons given by the Supreme Court for this particular advisory opinion stands in terms of not imposing any kind of timelines, etc., is to point to this whole separation of powers principle. You can't encroach on the governor's domain. You are the Supreme Court, and you will have to respect the governor's judgment, and therefore, we will only, step in if there is a glaring case of delay.
This is like a 6-year or a 7-year or 10-year. But if it's a routine bill, something that needs to be just passed, a small amendment in a pay structure, the governor could pass it in a week. And if he doesn't pass, the state could come to the Supreme Court in a month saying that, listen, he didn't pass the bill in a reasonable period.
So, no, this separation of powers principle, how does this tally with the court's position on the speaker's powers, for instance? Was there no separation of powers conflict there? Because there it has prescribed timelines without any problem.
See, in the Speaker's case here, you must be referring to Justice Nariman's judgment, where he said, so he had basically said that he didn't give a direction to the Speaker to decide in 6 months. He's basically defined reasonable period as 6 months for the Speaker. So, and the Speaker was a party in that list, in that litigation. Here we have an argument raised by the centre is that the division bench went beyond the dispute. Here the dispute was between the state and the Tamil Nadu governor. The other governors were not party. The president was not the party. So without hearing them, how can you impose timelines on them? You need to have, you need to hear the other side also. And separation of powers is part of the basic structure of the Constitution. So, so what the court has said is that by deeming assent after a certain judicially ordered timeline, if you're deeming assent, then you're taking over a legislative duty of the governor or the president, as the case may be. And that can swing both ways.
Right. Right. So finally, Krishna, so if we are going to be looking at a situation where state government, the state legislature bills are going to be held up indefinitely, and now I don't think like all opposition ruled states which have been at the receiving end, they can't all be coming to the Supreme Court saying, my governor is not giving assent, nor is he given a reference to the president, nor has he given any reasons. So it may not be really feasible to come to the Supreme Court in every single case. So do you think the only viable solution here is to have an amendment on this, saying that the governor has to give assent within a particular time? And if such constitutional amendment, if such a constitutional amendment is made, that only then perhaps there can be some kind of a closure to this issue.
Ideally, yes, because if you want to include or incorporate something into the Constitution, then you have to go for a constitutional amendment. They could bring that. I don't think the states would be rushing at every instance that the governor has said, because there is also a rider on the governor's power to withhold a bill. If he is withholding, he has to give it back with reasons. If he is withholding, he cannot just keep quiet and withhold. That the court has been very specifically saying that you can't withhold without giving reason. You can't just sit on a bill endlessly. You have to return the bill with reasons. And also, if he withholds without reason endlessly, then the states can approach the Supreme Court saying that this is a glaring circumstance, and you can. So that is the opinion given by them, but that's an opinion. The judgment, on the other hand, the April 8 judgment is still very much alive.
Right.
There's been no review. There's been no review or a curative.
Is a review in the pipeline, do you think?
I'm not sure about that. I don't think so.
That's all I have for you, Krishna, in this episode of In Focus. Thank you so much.
Thank you so much.
Talking to you.
Thank you so much.